And joining us this evening on News 360, Shreya Singhal, the original petitioner in this case, and also Shashi Tharoor, Congress MP and one of the famous leaders on Twitter. Good evening to both of you. Shreya, let me come to you first. Congratulations. What is it like to win such a landmark legal battle against the government of India at the age of 24?
Thank you so much. It's a bit overwhelming, but I'm honestly at a loss for words. I'm happy. I'm excited. It's exciting because this isn't just my victory. It's a victory for anyone who uses the internet. Because I mean, as you just said, that 66A was so innocuous, was so vaguely worded, and it was really misused a lot. And I think that might have inculcated a bit of a fear in people from posting on the internet, which is one medium which is accessible to the masses in India.
Right. Something perhaps that was lost on our lawmakers when they passed that bill in a haste in 2008. I want to bring in Shashi Tharoor, the lawmaker on our panel tonight. Mr. Tharoor, one cannot put you in the dock, so to speak, because you were not in Parliament in 2008. Even so, as lawmakers across a board, barring perhaps the Shiv Sena today, laud what the Supreme Court has done, isn't it a matter of shame for Parliament as well? This amendment to the IT Act was passed as part of the more than half a dozen bills in 7 minutes in the winter session of 2008. So shouldn't Parliament take some responsibility here?
I think it was done in good faith, Smita, even though I wasn't there. When the question of the application of 66A came up during my time in government, I actually had a very good conversation with Shri Kapil Sibal. And you see, their concern was very much that in our country, the internet and social media could be used to inflame passions, communal violence, hate, and so on. And certainly when you had that episode of all the Northeasterners being forced to flee places like Bangalore and elsewhere because of rumors being spread on social media of alleged attacks on a particular community in the Northeast, all of this led them to feel there needed to be some measures available under the law to crack down on this kind of misuse. Unfortunately, it became increasingly clear that the operation of this law was liable to misuse and indeed was abused. You remember the episode of those two girls who got arrested in Thane, I think it was, for liking a Facebook post and so on. This kind of abuse, particularly by untrained policemen, the government tried to tackle. I remember we came up in the UPA too with a safeguard whereby the permission of an IG of police was required before you could arrest anybody under 66A. Right. But even that, the Supreme Court clearly found was not enough. And for people like me who have long been advocates of freedom of expression on the net, this is a very important victory. The existing provisions of the Indian Penal Code, however, against hate speech and inciting communal violence must be upheld efficiently as well.
Right, there are of course IPC provisions for that, and many would argue here, Mr. Tharoor, that if lawmakers applied their mind and there was indeed a debate on the amendment to the IT Act, then perhaps all this would have become clear much before the Supreme Court had to come into the picture, striking down 66A. What do you say for the BJP though? We had Mr. Jaitley, when he was part of the opposition, say that, you know, this is a draconian law, must be done away with. Mr. Sibal, of course, was in the line of fire, but the fact remains that the BJP's submissions in court pretty much echoed the Congress's.
Well, please don't blame the Congress. I think it seems very clear that the BJP is all over the place on this issue. They called it an online emergency at one time, and then they defended it before the Supreme Court as a very necessary piece of legislation. So clearly, with the BJP, where they stand depends on where they sit. When they're in opposition, the law is bad. When they're in power and they can use or abuse the law, then it's good. I mean, that kind of attitude should not be acceptable in our politics today.
Right. Shreya, let me take up the concerns that have been expressed by some leaders, including those who framed this law and who've defended it. Even with this section now scrapped, are there enough provisions in the law to ensure that social media is not abused to incite violence or to create panic like we've seen in the past?
Well, there is some worry about that. At the same time,
I think there are.
There's in practice.
Right, right, Mr. Tharoor.
Sorry, go ahead.
Sure, Mr. Tharoor, please continue, and then I'll go.
I think there are, because, you know, the IPC and the IT.
Shreya, I didn't have a chance to congratulate you on your victory. So during these awkward pauses, let me congratulate you on having had the initiative to raise this issue. It's a very important issue, and I think it's a good sign for the 21st century that in our country, young people are standing up for their constitutional rights. So that's a very important thing you've done. At the same time, we do need to ensure that the internet is not abused. I don't believe it has actually discouraged anybody from posting on the internet. If I've seen some of the vile stuff on the internet addressed to me or about me, I know there has been no greater sense of responsibility because of 66A. It is just that some have been able to apply and misuse 66A. Many like me who could have complained under 66A chose not to do so because I thought it would be wrong to do so. But I don't think it really discouraged people from going on the net. What is important, however, is to ensure the net is not misused, because then the question of what kind of laws we need will come back up, and with the BJP in power, we don't know what kind of law they will write.
Right. Shreya, do you want to go ahead now as a student of the law?
I completely agree with you, Mr. Tharoor, and yeah, I just wanted to say that, you know, I feel that 66A, this is what we've said again and again in our petition and what we've argued, was that it was so vague, and this is what even the judges in their judgment have said, that it's so vague they can't write it down. They had to only strike it. There's no way they can write it down or form guidelines for its use. And I completely agree with what Mr. Tharoor just said, that you know, it didn't deter people, which is why, as you saw, I mean, up to a month ago, there were still arrests being made under Section 66A because people were still posting posts. It was still being misused, even though it was reserved for judgment. And I just want to say that, you know, I feel that there are enough laws, we have enough existing laws in our IPC and in the IT Act, which deal with you know, hate speech, defamation, phishing and forgery. And I think that we should, instead of implementing or, you know, having blanket provisions that cover almost everything, you need to see specific crimes, because new crimes, with the advent of the internet, new crimes have been invented. You know, you have cyberbullying, which is a crime. There's people committing suicide, small, you know, teenagers, young teenagers committing suicide because of cyberbullying and trolling. I mean, they're serious crimes, and we need to look at not a blanket provision, but something that can be used in our diverse society, because India is so diverse with so many people there that you can't, I mean, you know, judicial minds in England couldn't come to a consensus on their on a section similar to 66A. You can't expect a policeman somewhere, you know, in rural India to come to a consensus whether to use it. Is it being misused or what? You know, people were being arrested within 24 hours of posting stuff.
Right. A reference to that, of course, being made by Justice Rohinton Nariman when he read out that landmark judgment earlier today. Very key points being made by you, Shreya. A question that I want to bring to both you and Mr. Tharoor, I'll begin with you, of course, is you said there are IPC provisions that exist to deal with a number of other issues that cyberbullying, for instance, may pose. There are some young women who've written on Twitter to say, look, there have been people who've put our numbers online, our pictures online, have made all sorts of criminal threats against us. In fact, female journalists have gone on to say that they've got rape threats online as well. Doing away with 66A, does that in any manner embolden cyber bullies like those, criminals, felons?
No, actually what I said was that we need to, the 66A was a blanket provision. We need to focus on specific crimes that have emerged because of the advent of the internet, and not, you know, have a blanket provision that was so vague that it was being misused as 66A. But, you know, I mean, there are laws for criminal intimidation, and, you know, I think that we've recently just changed our rape laws to be more inclusive in a way, but I think that we need to see that threats are being made on the internet, and, you know, it's another medium that has been added to the sphere of public life, and we need to extend our laws to that medium instead of having a blanket provision.
Right. Mr. Tharoor, weigh in here. You're not new to cyberbullying. You've been trolled several times over on Twitter.
Yes, I have. But I agree with Shreya. I think, you know, the important thing for us to understand is, I think the problem, one of the problems with the law, the way it was drafted, was that it targeted the means of communication rather than the crime itself. Whereas what we need to do is to criminalize the crime rather than focusing on the means by which that crime is to be committed. You know, incitement to rape is a crime whether you do it orally, in a speech, on the internet, in writing, in a newspaper, or on TV. The same for incitement to communal violence, the same for hate speech, the same for bullying beyond a certain point. All of these things can be criminalized as crimes, irrespective of how you do them and where you do them. And obviously, if you do them on the internet, you're just as culpable as if you do it with a megaphone or a microphone or on a TV screen. The point is, the crimes need to be acted against, and these are all already criminalized. So we need to ensure, first of all, that the laws that are in the books are, if necessary, updated to ensure that these additional means of committing these crimes are also covered. But equally, we need to make sure that when these crimes take place, that there is a sensible application of existing provisions, both to punish crimes and to deter future crimes. At the moment, as Shreya was saying, a sort of general blanket law that it's easier to arrest you if you've posted something on Facebook than if you actually go out and try and harm people more directly is rather silly. And in many ways, the Supreme Court, by pointing this out, I think has put the onus back on the law enforcement authorities to do their job properly in upholding the existing laws of the country against all these crimes.
Right, and since social media is here to stay, we do hope that the law enforcement authorities can come up to speed with ways to deal with the challenges that it poses. Thanks very much, Mr. Shashi Tharoor and Shreya Singhal, for joining us this evening on News 360.